Everyone, good morning, good afternoon, and good evening, wherever you are in the world. Welcome to the inaugural SIAC Academy Lecture. My name is Emmeline, SIAC's Business Development Manager, Legal, and I am pleased to be your MC today. We will now have Ms. Michelle Chiam, Deputy Center Director at SIAC, to deliver the opening remarks. Ms. Chiam, please.
Thank you everyone for joining us for today's inaugural SIAC Academy Lecture. The SIAC Academy Lecture marks the end of a very busy year at SIAC. As you know, an expanded SIAC Academy program was launched at the start of this year, and we have conducted 18 courses focusing on advocacy and arbitrator training, document production, a 10-part series on the theory and practice of enforcement of arbitral awards in Asia, as well as training for tribunal secretaries. The response from the international arbitration community has been very encouraging. The pandemic has indelibly changed the way international arbitration is practiced. We are glad that through the increased use of virtual platforms, the SIAC Academy has been able to reach a wider global audience through our courses and provide an avenue for knowledge and best practices in international arbitration to be shared and learned. In total, close to 700 participants from 34 jurisdictions participated in SIAC's courses in 2021. We would like to thank all faculty members for taking the time to participate in our courses and in generously sharing your knowledge. We would also like to thank all participants for attending and supporting our courses. This year, we also launched the SIAC Academy Alumni for participants of our courses to have a platform for networking. We hope to partner with all members of the international arbitration community, whatever stage of your career as you are at, to partner with you as you grow in your arbitration practice. In this regard, to support the SIAC Academy alumni in your continuing professional development efforts, we are pleased to announce that all SIAC Academy alumni will receive a 10% discount on course fees for next year's Academy courses. Looking forward to 2022, we have lined up a series of specialist arbitration courses for next year's SIAC Academy curriculum. The new courses will include a 5-part specialist arbitration series focusing on construction arbitrations, maritime and shipping arbitrations, energy arbitrations, IP arbitrations, and banking and finance arbitrations, as well as a 2-day primer course on investment arbitration. Updated and improved editions of the well-received Comparative Review of Arbitration Developments in Singapore and UK seminar, the Arbitration 101 Understanding the International Arbitration Legal Framework 2-day course, the Document Production and International Arbitration course, as well as the Tribunal Secretary's International Arbitration course will also be held next year. The full course listing for 2000 next year may be found on the SIAC website under the SIAC Academy page. We greatly appreciate your feedback and suggestions on how we can better meet your training needs as you progress in your career in international arbitration. Please spare some time to send us your suggestions on course topics using the feedback form at the end of this lecture. Today's SIAC Academy Lecture is part of SIAC's efforts to provide a global platform for dialogue on topical issues of interest in international arbitration and to promote thought leadership. Our keynote speaker for today's lecture needs no introduction. Professor Kaufmann-Kohler is the honorary president of ICA and is regularly ranked among the top arbitrators worldwide. We are honored and delighted to have Professor Kaufmann-Kohler deliver today's lecture. The lecture will be followed by a panel discussion. During the panel discussion, please feel free to use the chat function to submit your reactions to the lecture and questions for the panelists. To increase audience participation, selected members of the audience have also been invited to join the panel as guest panelists. The title of Professor Kaufmann-Kohler's lecture is Diversity International Dispute Settlement, the Why and How. Varied progress has been made in recent years on different facets of diversity in arbitral appointments. In the 2021 Queen Mary University of London International Arbitration Survey, 61% of respondents agreed that some progress had been made in terms of gender diversity in the last 3 years. In contrast, in the same period, less than 40% of the respondents of the same survey agreed that progress had been made in terms of geographic, age, cultural, and ethnic diversity. At SIAC, we understand the importance and benefits of having diverse arbitral tribunals and are supportive of efforts to increase the diversity of arbitral tribunals to cater to the needs of parties and the dispute at hand, bearing in mind considerations such as gender, age, geographic, cultural, and ethnic diversity. These efforts to ensure diversity converge with our philosophy of being truly global in our outlook. In this regard, the SIAC panel features an experienced international panel of over 500 expert arbitrators from over 40 jurisdictions. SIAC also has a non-published reserve panel for promising candidates who do not yet meet the minimum standards of admission for the SIAC panel. Arbitral appointments at SIAC may be made from the SIAC panel, reserve panel, or off panel. We hope today's lecture will provide more firepower and persuasion in changing mindsets as to why diversity matters and how it makes a difference in terms of the dispute resolution process and outcome. Without further ado, I'll now pass the time over to Professor Kaufmann-Kohler. Professor Kaufmann-Kohler, please.
Thanks, Michelle, and thanks to SIAC for having me today. I'm happy to be virtually in Singapore, and of course, I would have much preferred to be there in person, but this is the world in which we live now, and we are certainly very privileged to have this communication means. I'm privileged to give this inaugural lecture of the SIAC Academy. I will devote it, as Michelle mentioned, to diversity in international arbitration, and we'll do so in 3 steps. Can I ask for the second slide to be shown? Yeah, I'm just checking that I see the slide, and I trust the audience sees the slide as well. The first step is to explore why diversity matters in international arbitration. The second is to review the current state of diversity. And then the third one is to look at ways to enhance diversity. Before I address these 3 aspects, I need to give some explanation on concepts. International arbitration, I will cover both commercial and investment arbitration. Sometimes I will need to distinguish because there are differences. And maybe we should say at the outset that international arbitration has inherently some diversity inbuilt because of its international dimension and participation of actors from different jurisdictions. So the question is not really whether there is diversity, but rather whether there is the right diversity mix with respect to a given dispute and with and in the industry in general. Now, the second concept that I need to mention is, of course, diversity. That term covers a broad range of ways in which people identify. It includes gender, age, nationality, national origin, race, ethnicity, religion, culture, disabilities, sexual orientation, and socioeconomic status. Now, in our framework, I will naturally focus on gender and geographical diversity being some kind of loose proxy for race, legal system, culture, tradition, and particularly relevant investment arbitration, a state's level of development. Now, having circumscribed the 3 concepts, and please, you can stop sharing the screen now. Let me go to the first part. Why does diversity matter? The need for diversity, essentially there are 3 reasons. The need for diversity is recognized in most circles nowadays as a value in itself, a matter of justice towards underrepresented groups. That does not require, I presume, a long explanation. So let me go over to the second reason. Diversity is said to improve the quality of decisions. And it is true that there are certain behavioral studies about national courts that suggest that a group of people of different ethnicity, gender, or social backgrounds integrate various viewpoints in its reasoning and decision-making, and therefore produces better quality decision than a homogeneous group would do. These findings are, however, not uncontroverted, and other studies reach opposing results or find that effects of diversity on judicial decision-making is limited to specific areas of the law, for instance, sex discrimination in labor disputes. Now, there are fewer studies about the impact of diversity on international dispute settlement. One, for instance, suggests that the International Court of Justice judges tend to vote in favor of the state that has appointed them, or more topically, of the state that has a similar development level like their own state. In investment arbitration, there is a number of empirical work that aims at assessing the influence of factors such as policy preferences or development status. There's a study on exit tribunal presidents that found, however, no link between development status of the state of the president and outcome. There's another study in investment arbitration that concluded that developing country nationals, when they act as arbitrators, are less likely to have firm jurisdiction and liability. But I'm somewhat unsure about this proposition, but because it may be linked to the identity of the appointing party and to a possible appointment bias or to policy preferences rather than the development status of the country. There are also studies on international arbitration in more generally, and those emphasize the role of cognitive biases in decision-making. We all know of cognitive biases. And the studies also stress that groups of like-minded individuals are likely to share similar perspectives and blind spots for mistakes as well, and be more prone to groupthink. Now, if we look beyond dispute settlement, and I thought it was interesting doing this, and specifically looked at decision-making in corporate contexts. There we find, for instance, among the recent study, 2017 meta-analysis covering many 150 approximately primary studies in 33 different countries, that found that when women occupy CEO and top management positions, the companies tend to perform better financially. This is because the presence of women in senior jobs reduces risk taking and promotes thoughtful decision-making. Another study conducted last year by a Harvard business professor analyzed over 1,000 leading firms in 35 countries and 24 different industries, and found a correlation between gender diversity and productivity, but only, and that is interesting, only in environments where gender diversity is valued. So in those societies where gender diversity is valued, diverse workforces attract more investors, attract top-tier job candidates, and encourage the exchange of innovative ideas. And it seems to me that if these propositions or finding results in the corporate context are correct, there's no reason why we could not transpose this to collective decision-making in other contexts, such as precisely arbitration. So if I try to conclude on the second aspect of quality of decision-making being or not improved by diversity, it is true that there's no clear-cut scientific or empirical evidence that the quality of the decision is improved. But I would say that as a matter of common sense, one would expect that a diverse group takes into account more diverse viewpoints, various viewpoints, and thereby makes at least better informed decisions. That leads me to the third rationale for diversity, and that is that it increases the legitimacy of dispute resolution, dispute resolution method. And that rationale is particularly important for investment arbitration, although it is relevant for any dispute settlement mechanism. In investment arbitration, the criticism that has been voiced very strongly in recent years goes precisely to lack of legitimacy. That is not legitimacy understood as a legal notion, but rather as a sociological concept. It designates the acceptance of the exercise of authority by those affected by this authority who voluntarily comply with the decisions irrespective of the content, not because they're forced, they're coerced to comply, but because they recognize that the authority is justified, or if you prefer, legitimate. Now, viewed from this angle, it seems obvious that adjudicatory bodies that provide a fair representation or fair reflection of those who may be affected by its decisions stand a better chance of being accepted as legitimate. And studies of perception of domestic courts show that diversity can indeed be a powerful tool to promote public confidence in fairness of the fairness of the judiciary. Now, if that applies to court litigation and investment arbitration, there seems to be no reason that the same would not be valid for commercial arbitration as well. So now, having established that diversity does matter in an international arbitration, let's look at the current state of diversity. And that leads me to my second part. Let's look at some empirical data and start with gender diversity in commercial arbitration. According to a ICA report of a cross-institutional task force on gender diversity that was published last year, and is, by the way, a good source of information on the current state of diversity, of gender diversity. Women appointments over about a number of major representative institutions in 2015 amounted to 12% out of all arbitral appointments, and in 2019 had gone up to 21.3%. That is certainly an increase, an improvement over a few years, but it is still obviously far from parity. And taking just two examples, now we could go to slide 3. Let's start with the ICC statistics. The ICC statistics show total that the arbitrator appointment of female arbitrators from 2016 to 2020 were around 17%. So now, and more over 20 in the more recent years. If we look at the next slide, which is about SIAC appointment, gender diversity in appointment, that the orange bars being women and the blue bars being men. you see a higher percentage, but these are specifically institutional appointments and not party appointments. What that means is that the institutions are more likely to make a diverse appointment than parties, and that is understandable because parties are more risk averse when it comes to appointment and tend to appoint people who have prior experience and a strong record and not take risk in this respect, which of course does perpetuate the existing pool rather than allow new entries into the pool. When I show these slides, I should remember that I owe them to a NUS PhD researcher by the name of Umika Sharma, who was very kind and opened her stats to me and even prepared slides on the basis of her slides. I'm very grateful to her. Now, let's go to regional diversity in commercial arbitration and start again with ICC, which is slide 5. It's just the next slide. Here we see that the distribution by region, and I will not, it will be tedious for me to go through each one. You see them on your screen. But what is striking actually is let me see, do I have the regional diversity? Yes, absolutely. That's what you see on the screen. The 66% of arbitrators of Western European and North American origin is what interests me here particularly. And that can be explained by the origins of the main areas of traditional areas of activities of the ICC. But if you look at the way the cases have evolved, they have moved away from Western European and Northern American dominance to a surge of Latin American and Africa cases. And obviously that is not reflected in the regional diversity of arbitral appointments. We have a similar progress let's go to gender. Is gender diversity the next slide, please? Yes. Oh no, this is ICC intersectional diversity slides that takes non-Western female arbitrators and compares to Western male arbitrators. And you see, of course, that the intersectional diversity is obviously even lower than if you look at the two types of diversities separately. If I now turn to investment arbitration, which we will find on the next slide. By the way, scholars have calculated that at the current pace of gender diversity progression, it would take until 2250 to reach parity. Obviously, that is a long wait. Now, let's go to gender diversity in investment arbitration. And that is the number of appointments of male and females over time. So you see that it was extremely low at the in the first decades of investment arbitration, and it grew up to 16% in the last decade, but again, very much below parity. Now, if we look at regional diversity in investment arbitration, which will be the next slide. That's first stats about the entire number of investment arbitrations overall since the beginning. What matters is the column on the right at the bottom, where you see that all non-Western regions is 26% of total appointments. Now, the classification in Western and non-Western may be a little outdated, but it doesn't matter. It is helpful for our purposes. Now, that 1/4% of all appointments that are for non-Western arbitration must be put in context of the regional spread of disputing parties in investment arbitration. And the claimants' most frequent nationalities, that is the investors' most frequent nationalities, are US, UK, Netherlands, Germany, Spain. So all belong to the Western regions. As opposed to that, the all-time most frequent respondents are Argentina, Venezuela, and in fourth place after Spain, Egypt. So these are all non-Western regions, but for Spain. More granular analysis of the stats of recent years would show a diversification of origins of claimants and respondents as businesses from emerging economies increasingly invest abroad, and developed countries are more and more targets of investor claims. But even taking these changes into account, the disconnect between those deciding the disputes and those at the receiving end of the decisions is striking. How did regional diversity fare over time in investment arbitration? That is the next slide, thank you. Not as well as gender diversity, actually. Strangely enough, it was, as this slide shows, higher in the early decades than it is in the most recent two. I have no explanation for this. I could guess that it might have something to do with the professionalization of the arbitrator activity and professional arbitrators being more located in the West and therefore attracting more appointments, but that is more a guess than empirical evidence for this. And what you also see on regional diversity in investment arbitration, that unlike gender diversity, it has been stagnating over the two last decades at about 1/4 of appointments for non-Western arbitrators. Another interesting diversity statistics is found on the next slide, and it deals with counsel gender diversity. I also owe it to Mika Sharma, and it's based on the GAR top 30 list of last year. It is divided, as you see, between partners and non-partners. unsurprisingly, and deals with three major arbitration hubs: London, Paris, and obviously Singapore. It is interesting to see, and it is not a surprise, that the proportion in the non-partner category is higher for females than in the partner category. So the question here is it just a question of time until all these non-partner women become partners, or are there other hurdles to them becoming partner, like, for instance, an insufficient, poor retention of women in the legal profession? It was, for instance, documented in a study for the US by the American Bar Association. And that would, the poor retention would, of course, have to do with risk aversion that I already discussed, making it more difficult for new entrants to enter the pool. That leads me to actually thinking about the causes for the gender diversity deficit, or more generally also the geographic diversity deficit. There's certainly a historic underrepresentation, insufficient opportunities, unconscious bias, although maybe the awareness about the bias is rising, but there's still a lot of unconscious bias under vis-a-vis underrepresented groups, the risk aversion to first-timers that I already mentioned, limited information on less visible candidates, prior experience, preferences of appointers for prior people with prior experience, and for women, probably also a lack of flexible working arrangements, and at least pre-COVID, the requirement for frequent travels in this career, as women are still primary caregivers when they have families. And for women, there may be another factor, which is bullying and harassment, that may explain the poor retention at the higher career level. So that leads me now to my third part. We have set out the findings as to the current state of the gender and geographic diversity in international arbitration. The findings are rather sobering, and so the next logical question is, how can we improve diversity? And that leads me to this third part. Obviously, that is a topic that we can pursue in a panel and floor discussions, because there may be many ideas that come up in that about possible improvement initiatives. So I would just like to use the rest of my time to highlight three comments. First, there's, after the sobering findings, there is good news in the sense that the awareness of the diversity deficit is now well established in the international arbitration community. By the way, I could have added, but that would have taken more time and more stats, and I didn't want to drown you in statistics, that there's another diversity deficits, which is about age, that can be partly explained by the need for experience, but some experience, while some experience is helpful, you don't need decades of experience for being a good arbitrator in particular. To what extent the awareness of the diversity deficit is accompanied by a consciousness about the unconscious bias vis-a-vis underrepresented groups is still open, but it seems clear that that consciousness is also slowly growing generally in society and especially in our field and in the international arbitration community. There's another good news, which is that the awareness of the diversity deficit has triggered wealth of initiatives and projects of all sorts to try and improve the current status. Second comment, I would like to look more particularly at investment arbitration, where we witness initiatives by states. So for instance, in treaties, and I would just mention the EU-Singapore FTA, where which provides for investment disputes for a court-like system that builds in nationality requirements. So that is about geographic diversity tailored to the contracting states. Other state initiatives are, of course, discussed in the UNCITRAL Working Group 3 on the reform of ISDS, where the lack of diversity has been identified as a concern that needs to be remedied. So how could these reforms by state increase diversity? One reason for the slow progress is the appointment of arbitrators by the parties or council, which perpetuate the small pool of usual suspects that have prior experience. The state might change this by providing for appointment by arbitral institutions only. It is not a very popular proposal among users of international arbitration, who insist on their right to appoint an arbitrator, but that would certainly improve the diversity record, as institutions are known for being more, tending more to deliberately work on diversity. Another proposal is for parties to select arbitrators from a pre-screened list or roster that would incorporate diversity criteria. Still another would be a creation of an investment court or an appellate mechanism whose composition would need to meet certain pre-established diversity targets. Now, leaving aside state initiatives, my third comment is broader and covers commercial and investment arbitration, and looks at the initiatives that various actors have started and could continue to launch and pursue. First and foremost, as actors, one thinks of the arbitral institutions in appointing arbitrators, of course, but also in staffing their internal bodies. There's a remarkable feminization, for instance, of the leadership in major institutions. SIAC first and foremost, but same thing in the Hong Kong International Arbitration Center, ICC, ICSID, LCIA, American Arbitration, and of course, all these institutions have also set up the ICA Cross-Institutional Task Force on Gender Diversity that has brought a lot of awareness and information and ideas about possible improvement tools. Other organizations that have launched various projects, and among these projects are the Equal Representation Pledge for Gender Diversity that has played a major role in raising awareness. There is early this year, there was a racial equity for arbitration lawyer projects launched. There is an initiative, there are initiatives giving access to information on arbitrators of underrepresented groups. So for instance, a list of African arbitrators promoted by the African Arbitration Association, or projects such as arbitrator intelligence, the list of arbitral women, that is the organization Arbitral Women. And in this connection, you may think of Lucy Reed's 5-minute rule, meaning when you draw up a list of possible arbitrators, take 5 more minutes to include diverse appointees. Large corporations actually are also now starting to demand diversity from their outside counsel. That may also be a push, both for counsel teams and for the list of candidate arbitrators. Interestingly, third-party funders have also a role to play in enhancing diversity. Burford Capital, for instance, has set up 2 funds to finance litigation arbitration entrusted to racially or gender diverse lead counsel. And last but not least, law firms can be instrumental in promoting gender and geographic or racial diversity. They can do this through promoting to partnership, through hiring, through mentorship, to flexible work arrangements and other initiatives. Now, my time gets to a close and it is time to reach a conclusion. It's hard to predict which initiative will produce what result. They certainly all supplement one another and deserve our attention and support. While gender diversity seems more advanced, the geographic racial dimension calls for even greater efforts as we go forward. All these efforts in the interest of a dispute settlement system that is fair and perceived as fair by all stakeholders. And I would like to thank you for your attention, and I look forward to the discussion now.
Thank you very much, Professor Kaufmann-Kohler, for the insightful lecture. We will now proceed to the panel. The panel will be moderated by Mr. Avinash Pradhan, partner at Raja & Tan, Singapore. And the speakers will be Professor Gabrielle Kaufmann-Kohler, who was lecturing earlier, and Ms. Weina Ye, international partner at Herbert Smith Freehills Kauai, Joint Operation Office. Selected participants have also been invited to join the panel as guest panelists during the panel discussion. I'll now hand the time over to our panel. Mr. Pradhan, please.
Thank you very much, Emily. And it's a pleasure to be addressing everyone today. And perhaps I could first say thank you very much to Professor Gabrielle for that hugely illuminating lecture. Perhaps I could first ask Weina. Weina, there was obviously a very interesting presentation. And perhaps I could just ask you to share your own comments based on your experience relating to the observations that were made by the professor.
Certainly. I also wanted to thank Professor Gabrielle Kaufmann-Kohler for the very informative and insightful lecture today. Obviously, I think diversity is the very broad concept, as Professor Kaufmann-Kohler has already said, and it involves a lot of aspects. What I wanted to share today is one issue that I felt that I've encountered again and again in my practice, but that point I think demonstrates Professor Kaufmann-Kohler's point today that increased diversity will help increase the quality of the decision and the confidence of the general public in the dispute settlement mechanism. So for the ones who know me, I am a dual sort of PRC and UK background lawyer, but I've spent most of my career in mainland China dealing with China-related disputes. And I've been working in this part of the world for over a decade, and one of the trends that I've seen, and increasingly in recent years, is that as I'm sure many have observed in the past years, that the increasing participation of Asian parties and Chinese parties in international arbitration cases, and I felt that that a lot in the past years, and in connection with that, we also see, what I've seen is that that there's an increased use of PRC law as governing law in international arbitration cases, as well as Mandarin Chinese as the arbitration language in those cases. But I think in contrast to that, I haven't seen as much involvement of a PRC background or Asian background arbitrators in those cases, where you would expect people of those backgrounds to be involved, and I think one of the consequences is that I do see that in many PRC law governed cases, for example, or even Mandarin Chinese conducted arbitration cases, you have a full common law background arbitrators in those cases, and also foreign arbitrators conducting arbitrations conducted in Mandarin Chinese. And that's problematic, really problematic from my perspective, because there really is a very significant difference in terms of the approach of applying the law by sort of a civil law background arbitrators and common law background arbitrators. For an example is that, for example, under Chinese law, the principle of good faith is very important, and that is linked to a tradition that Chinese parties do not tend to negotiate their contracts very heavily, and for $1 billion value contract, they might have 15-page contracts. And they're not very detailed, and so a Chinese judge or a Chinese arbitrator would not hesitate to apply principle of good faith or even principle of fairness when interpreting the contract terms, and they take a much broader approach when interpreting the text. But when the same issue went to a common law tribunal, they tend to take a very restrictive approach when interpreting the contracts. And that obviously will lead to very, very different results in those cases. So what we found in practice is that, the exactly same factual scenario, same governing law, PRC law, when the issues are presented to tribunals within China, administered by Chinese Arbitration Commission, and when that same case presented to the international tribunal conducted the international tribunal and administered by foreign institutions, you would have completely different results. And that relates to a number of aspects of a case. For example, how generous that this tribunal will be in terms of granting the quantum of damages, for example. There's a significant difference as well. And also there's a difference in terms of capability of languages. I've seen foreign tribunals trying to interpret contracts written in Chinese. Some members say that they speak Mandarin Chinese. Some do speak Chinese to a certain extent, but when they try to interpret the contract, they would heavily rely on a translated version of the PRC language written contract. And I think that really leads to some misunderstandings, in their decision-making process. And so that, in my view, it sort of undermines the confidence of the, the international dispute resolution process to a certain extent, and people do feel that sometimes maybe it's better for them to resolve this within China because you get the right background of people to decide your case. So it's a tiny aspect and an issue in the broad context of diversity, but I think that really elaborates and demonstrates the point that you do need diversity in this process.
I think it's a very pertinent set of observations, Weena, because it strikes at the heart of what Professor Gabrielle was saying about the necessity of diversity in promoting both the legitimacy but also the quality of the decision making, and that I think that really hits the nail on the head in sort of crystallizing the problem in real and concrete terms. I suppose it's interesting because here you've from your own experience, I suppose you've highlighted a real concern to commercial clients, and that puts into focus what I think it's quite fairly described as the lack of progress that has been made in terms of improving diversity. Perhaps I could just ask you, why do you think that is, given what you've just said? Because it sounds like there should be some immediate imperative to address the problem.
I haven't seen a lot of studies into this issue, to be honest, and I'll just speak from my own observations. I think perhaps two most important reasons. One is if you look at the statistics, and I'm speaking about HKIAC, institutions like HKIAC and SIAC based in Asia. If you look at their statistics in terms of appointment of arbitrators, top 5 nationalities of arbitrators are coming from common law jurisdictions. I'm talking about jurisdictions like Singapore, Hong Kong, UK, Australia, and Malaysia. And arbitrators from these jurisdictions consists of over 80% of their appointments. I think for both institutions, that is the case. I mean, it's natural, when it comes to appointment, you tend to appoint those who you're more familiar with, either from an institutional perspective, or from a co-arbitrator's perspective, and sometimes from parties as well. And then that's probably one of the reasons that that led to the situation that is the reluctance of appoint the arbitrators who haven't really been sort of absorbed into the international arbitration practice. And the second reason I think really is I also see that Chinese arbitrators are less active in international arbitration stage, and one of the main reason I see is the difference between the legal traditions from the two systems. Like, for example, in China, our arbitration practice is very different. Like, we have this med-arb procedure, which is very unfamiliar for common law arbitrators as well. We tend to adopt the inquisitory style. Chinese lawyers are less familiar with, for example, cross-examination. That's not something we use in China. We don't have document production process. And so because of the unfamiliarity of Chinese practitioners, or perhaps civil law practitioners, to those procedures, it's a lot more difficult for them to be integrated into the international arbitration field or stage. And then that's is probably one of the most important reason for that as well, I believe.
Thanks, Weina. Professor, could I ask you, I think just following on from what Weina has said, it seems to me that actually the issue is not just about diversity in terms of gender and in terms of geographical diversity, but actually what I think Weina is referring to is almost a conflict in the term, in the way one approaches the resolution of a dispute, or what is perceived to be fair or unfair in the way parties deal with one another commercially. And I wondered, is that something you've considered, and what are your views on that, both in terms of whether it's something that should be bridged, and if it is something to be bridged, how does one go about bridging the gap? Absolutely,
it was very interesting to listen to you, Weina. That falls into what I call diversity in legal systems or legal culture, which I have, for lack of time and a desire to be synthetic, put under geographic diversity. But it's obviously an important point, and I can see the differences both in substantive law. You speak about the importance of a good faith, of the way you interpret a contract, coming from a jurisdiction where good faith is very important, and in contracts, you can even interpret a contract against the words of the contract, which you could not do under common law. I understand these issues well. And then the difference in procedures is important too. Having worked a lot on med-arb, because I was interested in the system very much in terms of improving efficiency, I can see the difference. And now, how do you fix it? Well, by giving more prominence and visibility to local arbitrators, so they become, they can take center stage more and be active in international cases, not only in national ones, in domestic ones. And then you could go back to all the different types of tools, of course. But I mean, I would say it's probably a visibility issue. And maybe also we could be more respectful of local practices in international arbitration. We have moved towards kind of a standardized procedure with document production, with cross-examination that is far away from many traditional ways in a number of countries, including mine, for instance. Court litigation here is completely different than arbitration proceedings. So maybe we should also be more flexible in terms of procedures.
Thank you, Professor. I'm going to pause now, because I think what we'll do is we'll get our guest panelists who very kindly volunteered to participate with Weina and Gabrielle on our session today. Emmeline, do you want to get them on?
Yes, we've gotten them on. So I think we have Kareem. So we will just ask them to unmute themselves and turn on their videos.
Excellent, thank you. So everyone, I'm very pleased today to be joined by a number of very different people. So we've got Simon Dunbar from King & Spalding in Singapore, Stephen Lim from 39 Essex, also based in Singapore, Karina Goldberg, who practices out of Brazil in the firm of FCDF, and Mariana Zhong from Hui Zhong. So we've got a very diverse group of participants, and I'm very much looking forward, as I'm sure you all are, to the plurality of perspectives that I hope we're going to get today. Perhaps I could begin by asking Mariana to share her experience in response to what Weina has just said, whether she's experienced similar situations and similar challenges.
Thank you very much. First of all, I would like to thank SIAC for inviting me today, and also to Professor Gabrielle for your lecture. And then I think I fully agree with Weina that I think it is mainly because of Chinese practitioners and arbitrators' unfamiliarity with the rules of the game and the mechanism, and also I think language reasons. Those are the reasons that have prevented Chinese practitioners, arbitrators from becoming more active in international arbitration, in particular investment arbitration. And also, I believe, in my view, in my own experience, because I have like 12 years in American law firms operating in China, and then 1 year in Chinese law firm, Huizhong law firm. So my observation is that Chinese law firms, they are going through, I think, a transforming stage. On one hand, more and more partners, senior associates from international law firms are joining Chinese law firms, bringing them the experience. So Chinese law firms are able to take on some level of international commercial arbitration. And on the other hand, they still have very limited experience with international arbitration, in particular investment arbitration. Like for myself right now, I'm doing an investment arbitration, but still we paired with a firm in Washington, DC, because we believe we need their help in expertise in investment arbitration. So that is from investment arbitration experience perspective. And coming back to so-called gender diversity in China, I must say that I do not see a clear difference in terms of gender diversity in international law firms operating in China and in Chinese law firms, because I've worked in both systems. And to me, I feel it is the same situation that both ecosystems have very good percentage of hardworking and talented female associates. But then when it goes up, when it comes to partner, and the percentage drops very significantly. And China is perhaps even lower than the jurisdictions mentioned in Professor Gabrielle's slides, such as London, Paris, and Singapore. And in my own experience, in terms of working environment, I do not feel being treated differently, either in international law firm or in Chinese law firm as a female lawyer. But for me and for many other female lawyers in China, unfortunately, I have to admit, I think unconscious bias in gender, in age, and sometimes education background, I think is always there. And in terms of client preference, I want to say Chinese clients, especially new clients, they would always hesitate if their high-stake case is put in the hands of a relatively young female partner rather than a senior male partner with gray hair, although we have the same steady hands. So likewise, the Chinese clients are likely to nominate a senior-looking male arbitrators over female arbitrators because they have this perception that those male arbitrators are more trustworthy and have better judgment. So that is my observation. Back to you, Mr. Protham.
Thank you very much, Mariana. With that, maybe Karina, I could ask you. I should first of all say good morning. I think it's very early.
Good morning.
Thank you very much for joining us. And I wondered perhaps you could share your experience working in Brazil and provide a contrasting perspective or a different perspective from what Mariana and Rina have shared.
Thank you, Fred, and thank you, Professor Gabrielle. Also, it was very interesting to hear to the comments of Mariana and Rina. In Brazil, we actually don't have investment cases. Our cases are mostly commercial cases because Brazil is not has not signed, is not a party of the convention, exit convention. So in our commercial cases, because of the civil continental law tradition, we do actually replicate, as Professor Gabrielle just explained to us, we do actually replicate the procedures that are mostly adopted in international arbitration in Europe, in Western. So it is very Westernized, and this does have an impact in local practitioners and giving more visibility to local practitioners and giving more space to a different approach that could be that could come even from our experience in domestic cases. When it comes to gender diversity, this is still a big problem in Brazil, and watching to the ICA's numbers, we do have similar improvement in the around 2015, the numbers were lower, were around 10 to 20% of representative of women. Currently, we do have 30%. We have something that is very particular in Brazil, that the major domestic institutions, they do have closed lists of arbitrators. So currently, our stock exchange chamber, arbitration chamber, and also the Brazilian Canadian Commerce Chamber of Commerce, they are both the major institutions locally in Brazil. They have 1/3 of the names in the list that are women. So we think that this institution, there is a big pressure on those institutions to increase the number of participants. But mostly what we feel also is, as Mariana just reported, a very important effort to be played, a common effort to be played among council, the co-arbitrators that we appoint once they need to suggest names for the chair, as the chair of the panel. And so we should make sure not only that we convince our clients that we can choose for a more diverse option, and then make sure that this option would also consider names, more diverse names in their lists. And so I think here that we still need an effort from clients together with counsel who suggest the names, and then of the co-arbitrators altogether.
Thank you, Karina. That's very interesting. I think I want to pick up on some of those points, particularly with the steps that have been taken and how efficacious they've been. But before that, perhaps I could ask Stephen to give his thoughts regarding the importance of diversity in legitimizing arbitration. Stephen has a lot of experience in arbitrating in Asia across multiple jurisdictions, so it'd be very interesting to hear his perspective.
I think it's very important, Avinash, and thank you for that question. We have to bear in mind, let me speak concretely about Asia, because that's where I practice and I have the most experience. I think it has wider application as well. You know, Asia is a very diverse place. It doesn't make sense to talk about sort of one Asian identity, because it is an extremely diverse place. We have within Asia, India, for example, which I'm not Indian, but I'm sure, Avinash, you won't take offense if I say it is one of the most contentious societies. Amartya Sen himself wrote a book and called it The Argumentative Indian. And you have at the other extreme, perhaps, Japanese society, which is much more consensus based. And you would have the concern when you have disputes involving parties from these jurisdictions that perhaps they may not be understood by the people, the arbitrators who are deciding the case. I mean, just give another example, an Indian party, for example, may take commencing proceedings, whether in court or in arbitration, as the prelude to negotiation, whereas the Japanese party would think that once proceedings are commenced, that is the end of negotiation, and it's a fight to the death. So there are these cultural aspects which the party would want to ensure that whoever is on the panel deciding it would understand it and would see it in that context. When I get involved in appointment of selection of arbitrators, either as counsel or as co-arbitrator, quite often when you hear what the party wants, what they want to ensure that the person who's appointed doesn't bring with him any prejudices, unconscious bias, or inaccurate stereotypes about where that party comes from. In order for you to ensure that, I think you need to have a diverse panel. Having a panel that is made up of an Asian arbitrator, but say he's a Japanese arbitrator, hearing a matter involving an Indian party may not allay the Indian party's concerns about prejudice and stereotype. So I think diversity is very important. And coming back again to the point of what parties want, this may be oversimplifying it somewhat, but after all, the human element doesn't disappear in these issues. And ultimately, if you boil it down to what the parties want, they just want somebody to just understand them. As simple as that. And if you have a more diverse panel, then they have more confidence that when the decision is rendered, then it is not been influenced by any prejudice, unconscious bias, or any inaccurate stereotype. There's more likelihood that they would accept the decision, whichever way it falls, rather than feel that it is an unfair and unjust decision. So I firmly believe that a more diverse panel particularly in a diverse area like Asia, would give a better impression to the parties that this is a legitimate process and gain more acceptance.
Thank you, Stephen. That's very, very interesting, very helpful. Perhaps now I could turn to Simon. Simon, if I could just ask you this, from your perspective, are we moving to true diversity, or is it simply the case that a patriarchal Western model of justice is becoming more inclusive? What are your thoughts?
Thanks for that question, Evan. I think, well, firstly, I'd just like to say something about the premise of a patriarchal Western model of justice. I think what we have to bear in mind is international arbitration has the potential to be far more inclusive than almost any other system because of the level of party input into the decision makers. So I think to the extent, and well, there is an issue, the issue that there is goes to how that model is being used rather than the model itself. So if you look at parties have input into the institution they choose, which drives default appointments and the panels of those institutions. They have choices as to the choice of law that governs the contract, which often drives the profile of arbitrator that gets selected, because certain choices of law tend to indicate certain countries, and then that suggests certain profiles. And so I think when we're looking at the movement, which frankly is far slower than it should be, we need to look at why parties, and I think the premise behind the question is why in Asia, for very Asia-focused disputes, do we still have tribunals of 3 white men? And I think what we need to look at is who is making those decisions and how might they make decisions that align more with enhancing diversity. And I think what that comes down to is lead counsel in matters and the profile of the lead counsel in the region, and the extent to which they recognize the need for more diverse tribunals, but also looking at a more diverse pool of people when deciding who to appoint as arbitrator. And I think what happens is, in that regard, lead counsel look often at the usual suspects. Who do we often use? Who do we use before? Who are we comfortable with? And I think a lot of work can be done internally within law firms, both in the capacity building, but also in widening that pool. And I mean, the suggestion of taking 5 minutes, I think probably taking a lot longer. And every time we're meeting new people, every time we're interacting with them on committees, every time we're engaging with people who we haven't appointed before or are opposed to counsel, are we thinking, is this a potential candidate? What kind of case would that person be suitable for? And just keeping that list and building that list so that we have a more diverse list to go to when we're considering candidates. And I think more pressure will come from clients, and particularly multinational clients, on putting forward a more diverse slate. And I think that's encouraging. And the only other point I would make, I think, is it's something we do when we appoint experts more often, and particularly experts where it's not the regular expertise. We do an awful lot of research into candidates and profiles, and we may interview them and we may get references from people. We don't always do the same with arbitrators, and we tend to default to the usual. And so we can put the same amount of effort into arbitrator appointments as we put into more obscure expert appointments. I think we'll do a lot more work to broaden the pool. And I think that should be our focus, is broadening that pool of people, and maybe that'll get us a bit further towards true diversity.
Thanks, Simon. Perhaps I could come back to Weda. Weda, just hearing what Simon was saying, from the example or the observations that you were making earlier with respect to having an arbitrator that is better suited to the nature of the dispute in the context of the cultural differences that you see. Can I ask what your experience is, though, when you're trying to make or trying to put forward a more diverse choice for the client? How do you persuade a client that is appropriate, where it doesn't line up with, say, the cultural preference or the like of the person, of the client that you're dealing with?
I think First of all, I agree entirely with Simon's observation that the lead counsel's role in terms of appointing of arbitrators is enormous. You have your default candidates. I'd say from my experience, first of all, I will have my own different list of arbitrators. So obviously, you will want to choose the people who can judge your client's case in the best approach or the most correct approach that you would want. And so I maintain my list of arbitrators who I consider appropriate. For example, people who have Chinese or background, for example, or other Asian backgrounds, but they can also speak both languages or different languages, who can also understand witnesses who speak multi-languages in those cases. But I have to say, I think unfortunately the list is not very long, and ultimately, you also find that yourself in a pattern that you appoint those arbitrators again and again, and you soon run out of your list for your cases. And so that is an issue. And I suppose going back to what Professor Gabrielle was saying, it's very important that we enhance the visibility and for the arbitrators or practitioners from other cultural backgrounds. So we expand the pool, and so we can select from. Secondly, I think there are a number of initiatives as well. Big law firms also noticed this issue. For example, in the firm that I am with, Herbert Smith, I've been with Herbert Smith for a very, very long time. We have an initiative as to the new arbitrators coming from different, underrepresented groups. So each week we will have internally an introduction from of an arbitrator from, say, for example, Asian background arbitrator or a female background arbitrator. That way that enhances people's understanding of those arbitrators. And so when it comes to a case which might involve an arbitrator from that background, then you consider them. We also have policies, for example, in each case, you will have to consider at least one female candidate. And you need to include at least one female candidate when you present those candidates to a client. And so, that's all the joint efforts that we've been doing to promote diversity in international arbitration.
Oh, that's fascinating. Maybe I could turn to Karina and ask her, do you think there's room for similar or greater measures than that in terms of increasing diversity?
Definitely. It is very complicated still, because even among women, we see that we kind of repeat the same names most of the time. So as Vina said, it's really a matter of visibility. How can we take to clients different profiles? We will have to persuade them to show that we'll have to study the clients and to show to study the candidates and to show to clients that the background of that person that has not been considered or that has less previous experiences would be suitable for the case. And we need to be vigilant actually to be able to increase this visibility. During the pandemic, we had a group of women arbitrators in Brazil, and we saw that during the pandemic, most of the webinars, and it was a huge number of webinars, contained most of the times only men, only white men, and Brazil, like, it's a country that has more than 50% of the population that is Black. So we started to call the organizers of the event to ask them to consider whether even the events should have more diversity, because that's a way that everybody's at home watching, clients are also watching, and then you could make people to learn their positions, and then we need to be vigilant to get some improvement with diversity.
Thank you, Karina. Stephen, if I could turn to you, having heard Wayna and Karina, do you think enough is being done in Singapore. I mean, we saw the statistics which suggested that SIAC was perhaps doing better than the ICC and other institutions. But do you think we're doing enough? And if not, perhaps more importantly, because I think the answer is we're not. But the more important question is, why not? Why isn't Singapore and doing more, and why isn't Singapore better at addressing the problem?
I think it's come a way already. I know the SIAC is making great efforts to diversify its appointments. It makes great efforts to appoint younger arbitrators. It takes great effort to appoint women arbitrators. For example, I just had at lunch today with somebody who, a younger arbitration practitioner, who told me that he gets appointed by the SIAC and he's not on the panel. So it shows that SIAC is actually making a real effort to do that. So we've come a ways already. Is there more to be done? I think so. I think there is definitely scope for development. You do see still some, what might be anomalous cases, and you wonder why. You obviously you can't say because you're not involved, but you just read the case and you wonder why was that? Why was that? And Wena's comments earlier, reminded me of this. I read of a case that was an SIAC case that was governed by Chinese law. I think it might have been Mandarin as the language of the arbitration, or at least bilingual. But strangely, the parties appointed two arbitrators who are not Chinese, who do not speak Chinese, who ended up appointing a presiding arbitrator who also does not speak Chinese and is not Chinese. And they ended up having to run the arbitration effectively, I think it was run in English, and then having to translate the award after that into Mandarin. So you look at that, you wonder, why on earth? There may have well been strategic reasons why the parties went ahead and did that, but you do kind of wonder, why on earth do you end up in a situation like that, where the award actually has to be translated after it's written to be issued in Mandarin? So that ultimately, you only have to look at the parties and say, why did you do that? Why did you take that rather unusual course? And I think some of it is what Simon has said already, that people somehow tend to default to known names that they've experienced before, and maybe that's why it was done. I think people really need to be a lot more adventurous in how they approach their appointments and look beyond the field. I've done this. I tried to do this. I have appointed or tried to appoint younger arbitrators when I have the opportunity to do so. And I think people just need to get out there and step out of the zone that, let's go for the most well-known person. I think we should go for people who we know can do the job and who are more suitable in that particular case for that particular case because of the attributes they bring in. It may be that they speak a certain language, etc., or they have a certain background. But we do need all of us. I think this is where it falls on all of us. I don't think it's good for any of us to say we're not doing enough, because we have to look at ourselves and say, what are we doing individually to improve the situation?
Thanks. Simon, following on from what Stephen was just saying, I'm going to ask you a more specific question. So I've had the experience where dealing with in-house counsel, the concern is that when they game out the process of appointment in a three-party situation, the concern is that if you don't conform to the stereotype, what will happen is the other side will, and then the chair that gets appointed, all things being equal, will conform to the stereotype, and therefore your arbitrator is the one that's left out of the wing on the margins. Have you experienced a similar situation, and if so, how have you addressed it?
I actually don't think I have. You can see the concern. Well, you can understand that people may have that concern. I think the choice of some of it probably depends on how your presiding arbitrator is going to be selected, and if it's ultimately a default selection, you don't know whether that arbitrator will conform to the stereotype or not. And as thankfully, as we're seeing, institutions are being more diverse in their appointments. So it may backfire on you entirely if that's the way you're trying to decide it. And so I think I think it's incumbent upon us to look at the particular appointment, to discuss with that, where it's appropriate, discuss with that potential arbitrator their method of appointing the chair, and getting comfortable with it that way, if we have a list method or whatever it might be. But I think if it's a concern, it's one that should be assuaged as much as possible, and we should focus on the appointment at hand.
Thanks, Simon. Professor Gabrielle, I noticed that when I was putting the question, I think you were nodding your head, and I was wondering whether you had experienced a similar situation in your career and how you dealt with it.
Oh, it seems obvious to me that the first party which appoints, if that party takes a usual suspect, that it's difficult for the other one not to do the same, and then for the two-party appointed arbitrators not to take someone of similar stature. So to me, it very much depends on the first appointment, right? Because if the first appointment is, as Stephen said, more adventurous, and I know many young lawyers who would be very good at it when the older ones have already achieved a reputation. They do not need to prove anything. They can work less, actually. Let's be frank, and get away with it. Someone who's young, who has to establish a reputation, will do her best. And so the first appointment is in the dynamics relatively important, I would say. And broadening the pool is certainly a good way of doing it. I think that this is also a link between counsel diversity and arbitrator diversity, because if counsel gets more diverse, they will make more diverse appointments, just because they will identify with the arbitrator more easily. And so it's all an overall movement that needs to be pursued. It started, but there's a lot more work to be done.
Thank you. Mariana, perhaps I could ask you from your experience, what challenges you faced in trying to get a more diverse arbitrator appointed and how you overcome them?
Thank you. First of all, I would like to echo Professor Gabrielle's point that the more diverse the counsel team, the more diverse the appointment could be. I will give one example of my recent case that I worked with another US counsel on a case, and we approached and interviewed 5 arbitrator candidates, 1 from Asia and 4 from the Western world. And obviously it's a dispute between 2 Asian parties. However, our client is surprised that we have decided to go with an Asian arbitrator, but it is because my team is familiar with the Asian pool of arbitrators. That is why we put forward this name. We believe he is fully capable. He can carry the same weight, or if not even more, and influence into the tribunal, and to balance a Western tribunal if the other 2 arbitrators are from the Western world. So we talked to the client, the Chinese client, and we said, this arbitrator, this Asian arbitrator is very experienced, has a very high profile, and has received very good comments from the international arbitration community, including from the PCA. And eventually we persuaded this client to accept this Asian arbitrator, and we believe it is a good choice for us.
Thank you very much, Mariana. Well, I think that's all the time that we have for this evening. So I thank you very much to the panelists for the discussion, and I hope everyone in the audience has found it informative. With that, I'll just turn it over to Emily.
A big thank you to our moderator, our panelists, and our guest panelists for the insightful and engaging discussion. We hope everyone found the lecture useful, and we hope to see you at our future SIAC Academy courses. Have a lovely rest of the day, everyone. Thank you again.